No, I know I got a bit animated there, but we return to calm reading of this particular book. I am rather disgusted by this. I'm hot, so you know when the court's appointed counsel, like I want to ask Beverly Howard. Honestly, really in this whole baby Ashley case, I really do. I want to ask her, why didn't you turn the judge in for judicial misconduct? I mean, obviously the standard there is bullshit if it doesn't meet the standard, because this was disgraceful behavior. The judge had no business doing this. He's abusing the fucking system and his discretionary powers. This is corruption. Furthermore, it violates the Establishment Clause of the Constitution that, mandates that the government not favor one religion over the other. Well, he's clearly gone down the rabbit hole of endorsing Christianity. So he's already in violation of the Establishment Clause in this case. So that, Howard also filed a motion asking the judge to recuse him. So she tried to get him to do it, and he rejected the motion. He says that his personal views would not interfere with his ability to follow the law. I'm just like, bullshit. In support of this contention, Anderson pointed to the fact that his attitude about abortion did not prevent him from approving previous bypass petitions. Bypass hearings in Alabama and elsewhere ordinarily take less than 30 minutes. In these hearings, it's typical for the lawyer and the judge to question the minor in an effort to elicit testimony that speaks to the two-pronged bypass test. A minor usually answers questions that address her level of education, grades, future plans, career interests, and employment history. Her attorney commonly inquires about the medical aspects and risk of the procedures. The minor can also expect questions about whether she has considered alternatives to abortion, what plans she has made to handle any physical or emotional consequences, why she would choose abortion over other alternatives, and why she would make such a choice without involving her parents. During this bypass hearing, Howard posed questions along these lines, yielding testimony concerning the minor's level of maturity and her familiarity with abortion and its alternatives. Answering Howard's inquiry, for the minor testified that she was a high school's honors student with a college scholarship in hand. She had managed her own money, investigated the financial assistance available available should she have a child. She received counseling from Save It Life and the alternatives to abortion. She explained the risk of abortion and expressed her view that the proceeding with childbirth would interfere with her ability to pursue college. The petitioner also expressed fears about her father discovering her pregnancy, saying that he had been known to point a gun at boys who looked at her provocatively. In his position as guardian, McPhillips called two witnesses on behalf of the fetus over the repeated objection of the minor's counsel. These witnesses included a physician who testified about the physical development of the fetus and the executive director of Save Life Center, who testified about alternatives to abortion and her experiences with post-abortive women, who are all anecdotal, by the way. So, that's kind of a bullshit standard in of itself. I mean, despite my highly emotive nature in a lot of this and how animated this stuff makes me, I think you will find that if you pay attention to me long enough, that despite my rage at shit like this, that I am capable of being quite reasonable, in my takes and my stances on things, and I'm capable of being calm. But, this book, I've told you this before, was not an easy read for me. I mean, the first time I even tried, I found myself repeatedly throwing it across the room in just complete rage at what was going on. I mean, I'm going to be honest with you about this. It's blood boiling for me. I mean, despite the fact that I'm able to discuss it in a calm and reasonable tone, at other times, it's a very, very upsetting to know that this is going on at all, that this is the reality of the situation, and that other advocates in the pro-choice movement have not done the hard work of dismantling the case, for this, that it ultimately fell on me to read this book to you, to talk about this sort of thing. I find it really tragic, and I find it really... This book was like it came to me at a bad time in the way that when I had first found it, I was already kind of suffering from a belief that the court system, had favored people with deep pockets, and that, there was a two-tiered justice system, one for the rich and one for the poor, and that our legal system was fundamentally corrupt at the core. There really wasn't much good about it, and that really, to fix it, you pretty much had to burn it all the way down and rebuild it from the ground up, because there was just nothing, there was no saving this system. It needed an outright revolution. That means that you have to destroy what's there so that something else can take its place, basically. Because as long as the system's there, it's going to be an impediment to actually reforming it, so it has to be burnt down to prevent it from, preventing an alternative from rising up in its place. I found this book, and what was left of any faith in the legal system just kind of fell apart. This was just like a frontal assault on it in such a way that it just never ever was going to recover after this. So, I mean, I'm not a fan of the law or the courts or any of that shit. I guess you could say that I find the whole process in contempt, despite my calm following the rules, volunteering, actually going to jury duty and everything else. I really don't believe in the system. I don't. In his position, so he called two of them. I mean, see, this is the whole problem. Like Mr. Phillips calls two. He starts testifying about alternative abortion. She starts testifying about alternatives to abortion, and her experiences with post-abortive women. And that's what kills me about Save a Life as a group. As we've gone over, I kind of skipped over a lot about this group in particular, because it's just not all that, it's not the meatiest and most interesting part of the book. They just go over all the abusive practices that this group, subjects people to. And if you want to read that, like, I would just tell you to, go and read the book yourself. But yeah, you know, this is crap. And they talk about the emotional consequences of it. And I'm not saying that the women that feel guilt about it are invalid, but most women don't actually go through that experience emotionally when they actually have an abortion. Like, it's not all that common. It's well, I mean, it's the second most common symptom, but usually it's just relief that they feel. But at the end of the day, it really still, in second place, isn't really all that common at all that women go through it. And the women that go through it are, I hate to say this, but antidotal. They don't really say much about how the next woman who goes through it will, emotionally respond to an abortion. I mean, I'm sorry, it's just the reality of the situation. And women that regret it shouldn't be able to trample over the women that won't. Anderson allowed the Guardian considerable latitude in not only calling witnesses but in questioning the petitioner. During extensive cross-examination, McPhillips put many questions to the minor about the death of the fetus. For example, Miss Phillips asked the young woman whether you were aware that the baby already had a heartbeat. And are you not concerned after you've had that abortion that someday you may wake up and say, oh my gosh, what have I done to my own baby? Though the minor acknowledges that she may experience regret, Mr. Phillips persisted. You are not worried about being haunted by this? Have you had the chance to save the life of your own baby and you still wanted to go ahead and snuff out the life of your own baby? Mrs. Phillips invoked religion in pursuing the line of inquiry over protest from Howard's. He asked the minor whether she was familiar with the Bible scripture in which God says to the prophet Jeremiah, before I formed thee in the womb, I knew ye. And I'm just sitting here, like, with knowledge of legal objections, thinking myself, as I'm reading this, objection, facts not in evidence. Like, again, because it's like, Mrs. McPhillips, in this case, you've not proven that God exists at all. It's not been proven to the standard of any courtroom in the world that God actually exists. You've not presented any evidence to that regard. You're just asserting, which is hearsay at best. Mrs. McPhillips, who asked the minor if she prayed about her decision, I'm just sitting there like, why would you pray to a God that you don't even believe in? Like, after acknowledging that she had and indicating that her belief that abortion is a sin, Mrs. McPhillips asked if she was willing to pay the price. for this sin. You say you are aware that God instructed you not to kill your own baby, but you want to do it anyways. And you're saying here that today, that notwithstanding everything that you say, that you want to interfere with God's plan for your baby. I mean, the judge permitted all of this, and it's just, I'm sitting here like, I'm sorry, but nobody here has proven God exists. Among her many objections, Howard protested the use of the term kill, to which Mrs. McPhillip insisted, Your Honor, it's killing. I didn't say murder, although it is murder. This provoked another objection from Howard, who argued that the bypass hearings do not extend to the right to kill, but rather determine whether a minor is in a position to make a decision about abortion without parental consent. In an effort to make the questioning more palatable, Anderson suggested that the parties refer to the procedure as cooperating in the termination of the life of the unborn child. Mrs. Phillips, though, was undeterred. If you sugarcoat it too much, she doesn't understand what she's doing. Killing is what she would be doing. She chose not to, but in the event that you choose to have an abortion, I'd like to ask if she realizes that there's life there. Does she understand that the beating heart is going to be put to an end? After a 4-hour hearing that generated some 150 pages of transcript, Anderson granted the bypass, taking the opportunity to voice his own views about abortion and the life of the unborn. The judge offered the minor these reflections. I know this has not been an easy afternoon. We're dealing with a decision that is going to stop a beating heart, but what we have done here today is not for the purpose of giving you a hard time. I feel that we are dealing with the human life and an end of the human life. Whatever this decision is, and whatever the decision you do, I hope God will be with you. Seriously. So we've got violations of the Establishment Clause, requiring that the government not favor one religion over the other, or basically say that one of them is right. If the judge is the government's agent, then the government, through this judge, is violating the Establishment Clause of the U.S. Constitution by saying any of this stuff to the minor in this case. On top of all of that, we've got a problem, on the grounds that, first, like I said, Mrs. McPhillips wants to talk about the women who have experienced regrets and everything else, but it's like these women in the research community we would actually just refer to as anecdotal examples, and point out that they don't tell us much about how the next woman who has an abortion will feel about her experience. They don't. I mean, I'm sorry, but that's just the reality of the situation at hand in this. And I mean, I hate that I've got that accent when I say situation, but a yeoman's job of protecting the interest of his ward, to the extent that this unfortunate law allows. We call life as a brief passage in eternity. There must be a special providence for the unborn, who are not only deprived of the opportunity to live, but of having saving faith in spite of the sin whose commission is the natural inheritance of a man. I'm just like sitting here like, oh my God. One of these, like, I realize that that's an ironic use of oh my God, by the way, but I use it to express dismay. Not that I'm a believer in any higher power. It's a force of habit, inheritance of man. I'm sitting here like, this is one of the reasons why I don't consider myself a Christian anymore, in a big way. Now, I've said it myself. I don't associate with certain people that I find to be really embarrassing, and I wouldn't want people to think that I was anything like. I've kicked people out of my life because I felt that they were just such a terrible example to other people, like a friend that, literally was running around with women and getting them high on not, exactly soft drugs, but hard ones like meth and heroin, who literally met somebody that was, in recovery and decided to start using with her and pushing her back under, the tide of her addiction. When I found out about it, I was disgusted pretty thoroughly. It shook me out of a state of denial about him as a person, but I also realized intuitively, if I don't get out of this friendship, people are going to think I'm like him. And that was just it. It was like, I can't do this anymore, man. We are not the same as people, So, with all that, said, and everything about all this, like, I just like, I feel that, this idea that, he's saying that in spite of the sin whose commission is a natural inheritance of man, I'm sitting there like, yeah, according to you Christians, we're all being punished for the sins of Adam and Eve, which is insane. This is one of the reasons why I'm not a Christian, because that's bullshit. Like, what? Your God can't be just if he's punishing us for other people's sins. You know, that's just not fair. And under no way that there's any fairness to any of that. You know, Despite these comments, Anderson insisted that he felt confined to the waiver of parental consent pursuant to state law. For the record, made through almost 4 hours of testimony and arguments of the most acrimonious nature, it is clear that to the court that a waiver is not in the best interest of this young woman. It is certainly not in the best interest of the unborn child. Those findings are abundantly clear from the efforts and evidence of Mr. McPhillips. But unfortunately, those two findings are not determinative of the issue raised by this proceedings. This court is bound to uphold the law, however distasteful that may be, and regardless of whether the law is consistent with the court's fixed opinions. This is the law. Required consent shall be waived if the minor is mature and well informed enough to make a decision on her own. The court hereby grants the minor's petition for waiver of consent. Yes, but only after putting her through, an intense ordeal. I mean, Jesus Christ. And again, I don't believe in Jesus, but dismay. The provisions enumerated in the Alabama parental consent statute afford minors the right to appeal a judge's denial of the bypass petition. No other party is explicitly given the right to appeal. This is in fact notwithstanding. Mrs. McPhillips sought and received a stay of Anderson's order and appealed the decision to the Court of Civil Appeals. By challenging Anderson's orders, Mr. McPhillips provided the Alabama appellate courts an opportunity to rule on the permissibility of guardianship appointments. Both the Court of Appeals and the Alabama Supreme Court, to which the case in dispute eventually fell, passed up this opportunity. Rather than ruling on the broad question of whether the guardians' appointments are legally appropriate in the context of the bypass hearing, the Court of Civil Appeals confined itself to the narrow question of whether a guardian once appointed has the right to appeal the grant of a bypass petition. In a one-page per curiam opinion dismissing the appeal, the appellate court explained that the right to an appeal in such cases is purely statutory. Furthermore, the legislator did not provide the right to appeal from granting a petition for the waiver of a parental consent. The statute specifically states that an appeal may lie for any minor to whom the court denies the petition. The specific wording does not leave room for judicial interpretation. In this case, no minor was denied a waiver. Therefore, there is no right to an appeal. Faced with this dismissal, Ms. Felix appealed to the Supreme Court of Alabama. In a ruling issued on August 3rd, 1998, the High Court affirmed Anderson's decision to grant the bypass of consent. All the judges concurred in the finding that the minor proved herself to be sufficiently mature and well informed to proceed with the abortion absent parental advisement. Nevertheless, the ruling was sharply divided over the issue of whether a guardian can appeal the grant of a bypass petition. The court's per curiam ruling joined 4 justices and conferred with the fifth states. The legislator, as the Court of Civil Appeals correctly noted, did not provide a right to appeal from an order granting a petition for a waiver of parental consent. We can conclude that the legislator understood its subordinance to the supremacy clause of the United States Constitution, and that it recognized, pursuant to the United States Court's decision in Roe v. Wade, that it could not constitutionally confer upon a non-viable fetus the right to appeal through a guardian ad libitum in an order granting a minor a request to have an abortion. The opinion rejects the right of the fetus to appeal through a guardian, but neither rejects the right of the fetus to appeal through a guardian, but neither rejects nor confirms the trial court's authority to appoint a guardian ad libitum in the first place. Instead, the decision of the Court of Civil Appeals is silent on this point. Diverging from this opinion, 4 judges expressly addressed the legitimacy of the guardian appointments, and argued in favor of the guardian's right to appeal. The opinions of these justices supports Anderson's application of Rule 17 and cites precedent requiring the appointment of a guardian to represent the interest of an unborn child during certain types of divorce proceedings. If a guardian ad litem is required for an unborn child and when its legitimacy is at stake, then A4D would appear that the appointment of a guardian ad litem, although not specifically provided for, and the parental consent statute would at least be authorized, if not required, in a case such as this one involving a minor who is seeking a waiver of parental consent to have an abortion. Having established their position on the legitimacy of guardianship appointment, the dissenters also argue that it is well settled that a guardian ad litem appointed to protect the interests of an unborn child has a right to appeal. It seems clear that the legislator intended in adopting parental consent statutes to preserve the life of the unborn, and it deliberately was doing what it could within the constraints of the federal constitution as interpreted by the Supreme Court of the United States. To accomplish that purpose, the general rule of law that guardians ad litem are desirable in many proceedings to ensure that the proceedings will have adversariness necessary for the full presentation of the issues and the proceedings now here for the review. Such an appointment would be consistent with the purposes of intent of the legislator in adopting a parental consent statute. We conclude that the legislator, when provided the minor a right to appeal, did not intend to prohibit a guardian ad litem appointed to the representatives of the interest of the unborn child from appealing from an adverse order. Stated differently, we do not believe that the legislator, by failing specifically to provide in the parental consent statutes for a guardian ad litem's right to appeal, intended by omission to defeat the right of such an appeal. When four justices indicating the trial court may appoint a guardian ad litem to represent the fetus in bypass hearings, and with other five justices remaining silent on a point, Alabama's trial courts retain the discretion to designate an agent to speak on behalf of the unborn. Indeed, as Mrs. McPhillips explained, the Alabama Supreme Court decision was a victory, at least on this point. Four judges were saying that I should be a guardian for the unborn, but others didn't even comment on the issue of whether I should have the right to be a guardian ad litem. I talked to the judge, Judge Anderson, and he deserved an award for being a profile and courage, and we took that green light there for being the right to have a guardian, and so he continued to appoint guardians for the unborn. In an effort to explicitly sanction that which the Alabama Supreme Court did not, and the Alabama legislature in 1999 considered a bill requiring that an attorney be appointed to represent the state in bypass cases, granting the trial court the option of designating a guardian to represent the unborn. Drafted by the president of the Alabama Pro-Life Coalition, the bill died in committee, but not before being endorsed by then Attorney General William Pryor. According to one news report, Pryor, one of President Bush's controversial appointments to the federal bench, was reported as saying that an attorney representing the government should be involved to protect the state's interest in preserving life. In addition, Pryor said that he envisioned attorneys with networks in Alabama for life, of which he used to be a member, agreeing to represent the state for free and potentially taking an adversarial position against abortion. Notwithstanding this legislative failure and given the green light provided by the Alabama Supreme Court, Judge Anderson has made it a routine to practice to appoint guardians at bypass hearings. Judge John Capel, also of Montgomery County, has also adapted this practice. As a result, since the 1998 case in which Ms. Phillips served as guardian, at least 3 different attorneys have represented the unborn in at least 17 bypass hearings. Those who have represented the unborn since Ms. Phillips admit that their common objective is to protect the fetus' interest in being born. As one guardian explained, in a nutshell, my role is to protect the interest of the unborn child, and I believe that my role through the questions is to see if I can change the child's mind and convince her to carry the child to term. Another explained that the law is clear. If this girl is mature enough and they have the right to make that choice, my job is to see if she meets these conditions. But my job, the guardian said, is secondary. I'm there representing the unborn. My goal primarily is to save the life of that unborn life, the child's life. The unborn fetus has no voice other than my voice. If we don't make sure that that voice is heard, at least to the limit of the law, then the unborn fetus doesn't have a chance. To give the fetus a chance, guardians try to demonstrate that the minor, there is a living human growing inside of her body, that she may suffer physically and emotionally as a result of aborting the fetus, that some women who have abortions develop psychological problems and may even become suicidal, that there are many families willing to adopt, and that money is available to assist both with prenatal care and the raising of the children. They do so through extensive cross-examination. One guardian explained that the questions presented during the cross-examination they overlap to some extent with those posed to the minor by her counsel. Among these questions is where do they intend to spend the night? What are the risks? In addition, the guardian also asked, have you talked with anybody who had an abortion before? Do you know that people who suffer for abortions tend to be more suicidal? Have you watched any videos? I'm just sitting there like, ugh. Similarly, as a guardian explained, I'll go through the preliminary questions, her school activities, what her career plans are, do they have a job, do they have a bank account, what kind of maturity do they have in general. The guardian continues through a list of some 70 questions to inquire if they've seen pictures of the baby, of the fetus, if they've talked to a medical doctor, and then a whole series of questions about how the procedure is performed, what the risks are, and what the complications may be, what they will do in the event that they confront complications. I discuss psychological and emotional consequences, post-abortion syndrome in men and mothers as well. Ask if they've talked to any adults, administer a counsel at school, clinic, if they've seen any videos or printed materials about the procedure, and then I ask them about alternatives to raising it themselves, adoption, Catholic social services. There are a number of agencies that will take the child. I usually ask if there have been any pro-life agencies. Do they believe that this is in their best interest? I ask if she thinks abortion is wrong. Then a couple of scenarios, if there was a couple inside the church, well-educated, and they couldn't have a child, and they really wanted one, would should be consider giving the child to them for adoption. I try to get them to think if there are alternatives. Usually, we'll try to we'll ask if they go to church, what church, and what's the view of the church regarding abortion. Have they thought about whether there are churchgoers who want to adopt, and do they attend regularly? Owing to the fact that guardians are obligated to advance the interest of the fetus, the question puts the minor in many instances designed to compel her to consider the nature of human life, personhood, and killing. A minor will typically be asked to ask whether she believes abortion is wrong and whether choosing abortion runs counter to her religious views. If the minor answers that either of these questions affirmatively, she will be expected to resolve the discord between her belief and her decision to terminate her pregnancy. Indeed, one guardian went so far as to ask a minor who's already had a child whether she could imagine killing that child. When the minor said no, the guardian pressed her to explain how she could justify aborting the fetus she was carrying if she could not conceive of killing her born child. Guardians sometimes use fear to persuade the minor to forego her intended course of action. Consider the following report of a guardian's questions taken from the dissenting opinion in an appeal to a bypass hearing. The minor testified that she and her boyfriend plan to marry when they are older and that they have discussed having 3 children. The lawyer the trial judge appointed to represent the fetus asked if the minor, knowing that one of the risks you are going to face and is the possibility that you will be sterile after this procedure, was willing to place your future 3 children at risk. The lawyer then asked if she died as a result of the abortion, would that not take away not only your 3 children, but your boyfriend's future wife and his 3 children? The lawyer also asked if the minor had ever heard of post-abortion syndrome in men. He asked if she was aware that men are very often affected psychologically by their child being taken in an abortion, and that if she was willing to place her boyfriend at the same risk that she was taking. The lawyer also said to the minor, if you did have a complication and you have to go to the hospital, your church congregation is going to find out what's happened. How is that going to affect your going to church every Sunday? I'm just sitting here I don't go. God, seriously. While guardians use cross-examination as the primary method for advocating birth over abortion, some guardians have called witness to present evidence on behalf of the fetus. Like Mrs. McPhillips, the guardian brought in the director of a Save a Life Center to testify about the psychological effect of abortion. These guardians put on the record on the testimony of a woman who had previously undergone an abortion. They cite these people as experts. I'm going to go get some soda. Got to pop. So anyways, as you know from my previous videos, the way I feel about this is that if this doesn't meet the standard for, what the courts would define as judicial misconduct, then the standard should be rewritten so that it does. I mean, the abuses that are documented here are so egregious that, the law is offensive, and the problem if it doesn't consider these practices misconduct. And that makes the law itself the problem, not my take on this issue. The law needs to be changed so that these things actually do meet the standard, because the abuses that we are now getting into in this book, and the chapters that we've been reading together, or that I've been reading to you, demonstrate, why precisely the law itself is the problem, and not my take on this. When guardians use cross-examination, she brought two two other women. So N equals 2 here, which is not representative at all of a larger population of people. The guardians are also put on the record on the testimony of a woman who had previously undergone an abortion. These, quote, experts, unquote, were called to try and put out information. One explained that the lady who had an abortion said once that if she had done it 20 times, if I had known what I know now, I would never have done what I did. So information is the tool. With that testimony presented, the guardian asked the minor whether she knew what she was getting into. Additional opportunities for appellate review have emerged within the continued use of guardians, but these have yielded little beyond the 1998 decision. In 1999, a court of civil appeals considered a case in which a minor's appeal of a bypass denial was accompanied by a guardian's motion to file a brief in support of the judge's order. Overturning the judge's denial of the bypass request, the court also rejected the guardian motion. In a footnote without explanation or support, the Court of Civil Appeals wrote that a majority of the Alabama Supreme Court did not address whether the trial court had the authority to appoint a guardian for the fetus. Likewise, in this case, we do not address the propriety of appointing a guardian, as we have denied the guardian's motion to file a brief in support of the trial court's order. In 2001, a minor appealed the judicial order denying her bypass request and directly raised the question of whether the trial court had violated her constitutional rights by designating an agent for the fetus. The Alabama Supreme Court ruled that the trial judge had erred in denying the bypass and offered the following characterization of the guardian's participation. This was not a non-adversarial proceeding. The minor was cross-examined by a lawyer to represent the fetus. She adhered to her testimony and to her position that an abortion was the most appropriate course of action for her, despite being given full exposure through an extended cross-examination to opposing viewpoints that strongly emphasized the negative effect of an abortion procedure and advocated the benefits of having a child. While explicitly acknowledging the presence of the guardian generated an adversarial hearing, the court sidestepped the opportunity to address the proprietariness of designating agents for the fetus. In light of our holding, we pretermit any discussion of the minor's argument, considering the trial court's appointment of the lawyer to represent the fetus. One Alabama Supreme Court justice has registered criticism of the guardian appointments in a harshly worded dissent challenging both the denial of the bypass request and the appointment of a fetal representative. Justice, was the hero for whatever he said here, Justice Douglas Ing Johnson characterized such appointments as gratuitous and claimed that the petitioner was a victim of prejudice against abortion. Quoting the hearing transcript, the dissent criticized that the judge's statement to the minor that appointing a lawyer to represent the unborn child allows someone to represent the silent voice in this case. Johnson argued that gratuitously appointing a guardian ad litem for the, quote, silent voice cast the inquiry as a contest between the baby struggling to save its own life and the mother fighting to kill the baby. Yeah, I mean, this is fucked up. Judgment is the Lord and is eternal. God damn it. Judge Anderson has suggested that guardian assignments help ensure that the minor is asked the right questions. No! God damn it, like, you're so wrong. At the hearings, and frees the judge from the position of cross-examining the young woman. Nevertheless, not even Anderson claimed that this is the main reason for the guardianship appointments, and there's no question that the primary motivation for such appointments in Montgomery, Alabama, is judicial opposition to abortion. By all accounts, Judge Anderson and Capel oppose abortion. According to one attorney who has represented the minors, it has been said more than once to Capel, you have to put your personal opinions aside on this. He is adamant about abortion. Another suggested that the emergence of guardianship appointment owes to the fact that both Anderson and Capel are personally opposed to the concept of abortion and want somebody fighting against that. Similarly, Beverly Howard stated in a televised interview after representing the minor in the first case involving a guardian, I think this case came about because the judge assigned to hear it is a well-known as opponent of abortion, as is Mrs. McPhillip, who is a member of Attorneys for Life, and not necessarily because he believes that the laws. What's happening to the people who oppose abortion are using this as a form to get to people or girls that they normally wouldn't be able to speak to outside of a clinic. In the courtroom, they're able to get within 2 feet of them, and a girl, in the case of a minor girl, is ordered to answer the questions asked. And some of them, I think, are highly inappropriate in a judicial setting. And I happen to agree with her. I just wonder why she hasn't actually filed against the judge himself in this case for judicial misconduct, because this was such a clear-cut case of it. It's not surprising that some attorneys who represent minors explain that the appointment of guardians in terms of ideological views of judges, but they are not alone. Designated guardians have similarly pointed the pro-life views of these two judges as the motivating force behind the appointments. As one guardian asserted, Judge Anderson doesn't want anybody to get an abortion. He's very religious and he doesn't want to grant these things. According to another reason, Anderson and Capel provide fetal representation to try to persuade the child to carry the fetus to term. It's all really fucked up. Consider also the comments of Mrs. McPhillips, who's sharing in a televised interview camera, explain why Anderson chose him, to serve as the guardian. I have a heart for unborn children, just as I do for all underdogs and victims I represent in my law practice. In fact, I said there's no greater underdog or victim in life, and I emphasize the words "in life" than a baby who's about to be killed in her mother's wounds. When Mrs. McPhillip explained to me how he came to represent the fetus, he said, well, the judge who was handling the case was a very conservative Republican, very pro-life, and I knew he was pro-life. The widespread and uncontested perception that Anderson and Capel appoint guardians because of their view about abortion derives from the fact that these judges have not been shy to express their views. During an interview with me, Anderson was forthright in explaining the genesis of the guardianship appointments in protecting the innocent life of the unborn. It bothered me that the truly innocent party was unrepresented, so I came up with an idea that perhaps a lawyer should be appointed. In June 1998, I was at a lawyers' conference, and they had a question period and a discussion about guardians. So I asked a question: whether if someone were to appoint a guardian ad litem to represent an unborn in waiver hearings, what would happen? And a judge said, I wouldn't touch that with a 10-foot pole. So I thought I would ask for an attorney's general opinion about whether I had the authority to do that. Well, he was a newly appointed Republican with an election coming up, and I didn't want to do that to him before his election. So I ran it by him at another lawyers' conference, and he said, if I had to ask you, if I had a question for you, could I ask? And he said, yeah. And he said yes. In the meantime, before I could ask that question, that paused one of these cases, and I have to have a real soul search. If what I believe is right, then I need to do it, regardless of the consequences. Either I believe what I say or I don't, and I believe it, and consequently, I appointed Julian. Anderson described his continued use of guardians in similar terms. You know, this is just ridiculous. The reading from an unspecified Alabama ruling that did not deal with our parental consent. It did not deal with our parental consent for abortion. Anderson quoted the following passage: our Supreme Court has said it is the court's duty to guard and protect the interest of infant wards and with scrupulous care. Anderson went on to explain that in light of this, judges have a heavy burden in bypass cases, and specifically a duty to protect children both born and unborn. He admitted that he believes that abortion is the wrong decision, and suggested that Capel shares his view. When to reflect on the fact that his appointment of a guardian may turn out to be a precedent-setting mood, he offered the following response: I don't really focus on being the father of something because I've got plenty of more stuff to do, but if it saves a life, it was worth it. Anderson and Capel also candidly expressed their opposition to abortion during bypass proceedings. As discussed, Anderson clearly indicated his position about abortion to the young woman who faced questioning from the first designated guardian. Over the years, he has continued this practice. For example, Anderson complained to the minor in 2011 and 2001 bypass hearing, what you have asked the court is to allow you to do something that is extremely serious and fatal to your child, and it has been my practice for 3 years now when I'm faced with these cases to not have a lawyer for you, but to have a lawyer to represent the interests of the unborn child, and that is why he is here. Both the lawyers have in many, and I would say too many of these cases because one is too many. Capel also plainly expresses his pro-life position to minors. According to the report of one attorney, Judge Capel will usually say, this is an enormous decision, and I don't want you to make it. I want you to consider the life of this baby. It will stop a beating heart. Your baby right now is perfectly formed, has 10 little fingers, 10 little toes, and I don't want you to end the baby's life. And if you don't make this decision in 7 months, you'll be a mommy and you'll have a perfect little baby. Even when they grant bypass petitions, Anderson and Keppel convey their pro-life views. It's not uncommon for these judges to forthwithly state that they are constrained by the parameters of the law to grant the petition despite their opposition to abortion, and both judges typically remind the minor that in their written orders that such a grant does not require her to have an abortion. As noted earlier, Anderson indicated in one such case that his fixed opinion that abortion is wrong. He did he did in this case go on to grant the waiver request, though not before offering the following commentary. Judgment is the Lord, and the Lord is eternal. That his forgiveness and mercy are limitless. Conclusion. What transpires under the searching inquiry of the guardian is an adversarial exercise that pits a minor against an attorney who hopes to convince the young woman to adopt a particular conception of morality and personhood. In a non-adversarial process, a minor might be asked in a reasonable and neutral fashion whether she considered the potential emotional ramifications of her decision, but when an adversary inserts the picture, investigation along those lines can morph into queries about the minor's willingness to stuff out the life of her own baby. Thus, the act of introducing an agent to represent the fetus alters the nature of the bypass hearings in placing before the minor an adversary who is legally obligated to thwart her quest for an abortion. Inquiries are bound to, in fact, become aggressive in nature. Outside anecdotal accounts, we do not know whether pregnant minors have been deterred from pursuing bypass requests upon discovering that hearings in front of some judges, include questioning by representatives of the fetus. Neither do we know whether minors have traveled to another county or state to avoid judges that impose this measure. Now, the big thing that you really ought to know about my own take on this issue and my own feelings about abortion going into this, now that we've spent like 2 hours on the whole thing, I personally am I'm in favor of a woman's right to terminate, but I'm not in favor of it, on the grounds that you would think. It's not like I guess you could say that it's not like I have a moral preference for it being that way. For one thing, I don't want kids, so them having that right is good because it means that I also don't want to be single, so if I ever find myself in that situation with my partner, I don't I want there to be that option there available. But that doesn't mean that there isn't some part of me that gets the emotional nature of it and has a bit of a reaction to it. It's just that personally my reasons for supporting it are much like the doctors themselves who were the ones that treated women who tried to faced with these restrictions back before Roe versus Wade was a thing, would try to seek out illegal abortions. And it is on the grounds that I don't feel that what Roe versus Wade actually did was make, it didn't create abortion. All it really did was make abortion safer than it had been, because it had been with us long before Roe versus Wade existed. And so many women suffered septic shock because of the fact that they would, try to do something down there to the fetus themselves out of desperation. And this is what kills me, is that the basis of my support lies on the fact that when you deny women choice, they often do desperate, drastic things. You think that you can stop them from doing it, and I know you're wrong and misguided, and it really doesn't matter whether it's illegal or not, or if you define it as murder. They're going to do it anyways. Considering the potentially life-altering ramifications of having a child, if a woman wants to abort, she's going to find a way to do it. So it's on that grounds that I support it, because I can't stop them. I know this, and I acknowledge it.